Hello and welcome everyone. My name is Nick Wilcox. I'm a partner here at BDBF and I'm joined today by my colleague Julia Gargan, an associate in our team. So I want to just start by looking at what we're going to cover today. Sexual harassment in the workplace remains prevalent. The results of a survey run by the TUC revealed that more than half, 52% of all women, have experienced some form of sexual harassment, and that figure is higher for younger women at 62%. 20% of women have experienced unwanted sexual advances, with 1 in 10 experiencing unwanted sexual touching or attempts to kiss them. In the vast majority of cases, the perpetrator was a male colleague, with nearly 1 in 5 reporting that their direct manager or someone else with direct authority over them was the perpetrator. 80% of women did not report the sexual harassment to their employer. And it's for this reason that a new legal duty will require employers, for the first time, to take proactive steps to prevent sexual harassment at work or face paying an uplift of up to 25% of extra compensation for failing to do so. So today, Julia and I will unpack this new duty for you and explain what you need to do to discharge it. But before we do, we think it's important not to fall into the trap of thinking this is a mere box-ticking exercise. And so we'll start off today by just spending 5 minutes or so putting all of this into context. And we'll then move on to discuss what the current position is, what's changing, what the consequences are of breaching the duty and the consequences for settlement agreements, how employers can discharge the new duty, and we'll look at when a preventative step will be reasonable and what kinds of steps most employers will be expected to take. Now, we're going to speak for about 45 minutes, and after that, there will be some optional time for questions and answers. We're presenting in a webinar format today, which means that the best way to ask any questions is to type them into the Q&A box, which you'll find at the bottom of your screen. And you can ask questions anonymously if you prefer. Finally, today's session will be recorded, although the questions and answers won't be. After the session, we'll circulate the recording together with a copy of the slides that we're using today. So why does this matter? Before we explain the new duty, let's just remind ourselves of some of the consequences if sexual harassment is not prevented. Starting with risks to the business, to the employer, grievances and disciplinaries. Well, victims of the sexual harassment may well raise a grievance, and this takes a significant amount of management and HR time. If the grievance is upheld, then you will almost certainly need to commence disciplinary action against the perpetrator. And again, this will take a great deal of management and HR time and resource. All of this will almost certainly have an impact on the teams within which the victim and the perpetrator work. It may make working relationships difficult. People may take sides. There will probably be gossip and rumor. None of this is good for team morale. If you reject the grievance, and actually even if you uphold the grievance, you may well then face a legal claim from the victim, arguing that you, the employer, are vicariously liable for the sexual harassment. And you might also face other claims, such as in constructive unfair dismissal and in personal injury. If you dismiss the perpetrator, you might well face an unfair dismissal claim from them. Tribunal claims are time-consuming, expensive, and public. A typical harassment claim before the tribunal typically takes at least 12 months from start to finish, and that's before the possibility of appeals. And if you lose, you could also be in line for paying out significant compensation. Remember that compensation for harassment is uncapped. In terms of reputation, harassment claims will commonly be picked up by the press, particularly where the employer is based in the city. And this type of negative publicity could be harmful to the business and those involved, and it cuts across a commitment to be an employer of choice. And in turn, it could therefore harm your ability to recruit and retain top talent. FCA-regulated firms face the additional complexity of being responsible for determining individuals' fitness and propriety, and having to consider the FCA's view of the firm and its regulatory permissions. Now, it's well established that the FCA considers non-financial misconduct, as it's called, to be as important as financial misconduct. When we talk about financial misconduct, we mean things like market manipulation, things like insider dealing, insider trading. Non-financial misconduct, which would include sexual harassment, is a particular focus of the FCA at present. The Equality and Human Rights Commission, which is a statutory non-departmental government body with the power to challenge discrimination and enforce equality law, has the power to investigate where there's been a breach or a suspected breach of equality law, and the outcome of that investigation would be in the public domain. Now, remember that in sexual harassment cases, it's quite possible that a criminal offence has been committed. And if that's the case, you can become embroiled with a parallel criminal investigation and or prosecution. And that could hamper how able you are to manage your internal process. And inevitably, it may also mean the case is more attractive to the press, although in certain types of criminal case, the victim has a right to anonymity. Obviously, there are some very high risks to the victim, including in respect of trauma and mental health. Of course, it extends to the negative mental health impact of the harassment itself, which in the most serious cases can be devastating. Victims of sexual harassment will often also be concerned about retaliation from the alleged perpetrator, and maybe even from other colleagues, if the victim reports the matter. And that retaliation is known as victimization. If the employee is victimized, then that can give rise to a further legal claim in addition to the original sexual harassment. And linked to that, victims are often fearful that raising issues or taking legal action will harm their reputation in the industry. For example, in 2019, Bloomberg ran an expose of sexual harassment in the Lloyd's insurance market, where one female insurance professional said, and I quote, "If you sue, you will destroy your reputation and you basically have to decide that you'll never work in the insurance industry again." If the victim engages a lawyer for advice, they will incur significant legal costs. Now, obviously, there are risks to the perpetrator. Sympathy for the perpetrator's position might be somewhat lower, but in brief, those would include things like disciplinary sanctions, up to and including summary dismissal. And if you fail to take such action, then that could also lead to an award of aggravated damages in a claim brought by the victim. And under the new regime that we're going to discuss, it may also mean that you've breached the duty to prevent sexual harassment. The perpetrator could be named as an individual respondent to an employment tribunal claim alongside the employer and held by the tribunal to have committed sexual harassment and be ordered to pay compensation to the victim. Unless there's an anonymity order, that tribunal judgment is going to be in the public domain. If the perpetrator is FCA regulated, there are the fitness and propriety issues I mentioned, which in serious cases could be career ending for that person. And the perpetrator may well face a criminal investigation, prosecution, and sentencing. The sentencing guidelines for the types of sexual assaults that might occur in the workplace, such as touching through clothes, where there's no aggravating factor on culpability like premeditation, suggest that sentences will range between a community order to a custodial sentence of 6 months. Obviously, the perpetrator's reputation will be damaged, and outside the workplace, it's quite likely that the impact will be felt through the person's personal life, for example, through marital breakdown. So I next want to recap briefly on how the law stands currently on sexual harassment. On this slide, we have the legal definition of sexual harassment taken from the Equality Act 2010. First of all, we're talking about unwanted conduct. The conduct has to be unwanted for sexual harassment to be present. Therefore, a consensual relationship would not amount to harassment, although it could present a risk of harassment occurring at a later date if the couple breaks up and then one party continues to pursue the other or treats them less favorably because of the rejection. It's important to note that even if a worker has apparently put up with harassing behavior for a long time and hasn't complained, that does not necessarily mean that it's wanted. It may still be unwanted, but they may be afraid to speak up, particularly if the perpetrator is in a position of seniority. In the same vein, a worker might actively go along with or encourage certain behaviors like sexual banter for some time, but then reach a tipping point where the behavior becomes unacceptable. A one-off incident can be unwanted conduct, but there's no such thing as testing the water with someone to establish their boundaries. Behavior can be unwanted even if it's not directed at the complainant. So an employee is entitled to complain about harassing behavior, even if that behavior hasn't been directed to them or where there's no intention that that person will see it or hear it. If they do, they can still complain that the behaviour is unwanted. The meaning of conduct is wide-ranging, and it covers verbal, written, and electronic communications, as well as physical gestures. But it has to be, in this context, it has to be of a sexual nature. So simply put, if the conduct relates to sex, then it will meet the definition. Note that it doesn't have to be motivated by sex. So for example, if a male colleague was to paste a female colleague's face onto a pornographic image and then circulate it to colleagues to make fun of, this will be behavior that relates to sex but is not motivated by it. Other behavior will relate to sex and be motivated by it. For example, trying to kiss or touch somebody. So this kind of conduct will cover some obvious things like sexual advances and sexual touching, but it will also cover less obvious things like sexual jokes or viewing inappropriate material or sending emails containing material of a sexual nature like lewd images or words. Next, the unwanted conduct of a sexual nature has to have the purpose or effect of harassing. So when we talk about the purpose type of harassment, that means the behavior was intended to harass the person or to harass somebody. But when we talk about the effect type, even if the behavior was not intended to violate dignity or create the hostile environment, it can still be harassment if it did in fact have that effect, either on the recipient of the behavior or someone else. And when we're talking about the effect type of harassment, there is an additional test that kind of guards against overreaction, and it's an objective test, and that's to ask whether it was reasonable for the conduct to have had that effect on the victim. And then finally, it has to violate dignity or create a hostile, etc. environment. So when we talk about violation of dignity, dignity means the value that somebody has that makes them worthy of respect. Creating an intimidating, hostile, degrading, humiliating, or offensive environment, if the behavior in question creates that sort of environment, whether for the recipient or for someone else, then it could be harassment. From the employer's perspective, employers are liable for anything done by their own employees in the course of their employment. This is the case regardless of whether the employer knew about it or had approved it. And this is known as the principle of vicarious liability. So a key question then is, well, what exactly does in the course of employment mean? Importantly here, the words are given a wide meaning. Harassment of an employee by a colleague in the workplace will almost certainly be covered. The dividing line starts to become blurred where there's conduct off premises and outside normal working hours, especially at social gatherings. Some situations may be considered to be an extension of employment, like, for example, a colleague's leaving party, or even informal drinks with colleagues in the pub straight after work. But a chance meeting with a colleague in a bar on a Saturday night is unlikely to be covered as being part of in the course of employment. It's a case and fact-specific question that a tribunal would look at on a case-by-case basis. Where the employer is potentially vicariously liable, it will have a defence if it can show that it took all reasonable steps to prevent the offending employee from committing the particular act or anything of that description. And in summary, this will usually include things like the employer having and implementing an equal opportunities policy and an anti-harassment policy, and reviewing those policies as appropriate, making sure that all employees are aware of the policies and their implications, training staff on equal opportunities and harassment issues, and giving more in-depth training to line managers, and taking steps to deal effectively with reports of sexual harassment, including the taking of appropriate disciplinary action. Now, the key point is that all reasonable steps have to be taken if you're going to succeed in that defence, and that's a high threshold, and it often doesn't succeed. Now, what about liability for sexual harassment committed by a third party? For example, a contractor, a client, a delegate at a conference, or a member of the public. Are you, the employer, vicariously liable for that in the same way that you're vicariously liable for the acts of your employees? In short, the answer is no, and that isn't about to change. Until October 2013, the Equality Act made employers liable for harassment of staff by third parties, albeit that liability only arose where the worker had been harassed more than once. Now, the coalition government repealed those provisions on the 1st of October 2013. However, and confusingly, whilst the employer cannot be sued by an employee for third-party harassment, the new duty to prevent sexual harassment does require employers to take steps to protect staff from third-party harassment. We're going to come back to that point. So what is changing on the 26th of October? Well, from 26th of October, the snappily entitled Worker Protection (brackets) Amendments of Equality Act 2010 (brackets) Act 2023 will introduce a new mandatory legal duty on all employers to prevent sexual harassment. The new duty to prevent will require all employers to take reasonable steps to prevent sexual harassment of workers in the course of their employment. This is completely separate to and independent of the question of whether an employer wants to rely on the all reasonable steps defence in respect of its own vicarious liability for harassment by one of its own employees. To help us navigate what this new duty requires, on the 26th of September, the Commission updated its technical guidance on sexual harassment. It also provided a brief guide of 8 steps employers can take to discharge the duty, and we're going to work through that together. So let's unpack the new duty to prevent in a little bit more detail. What does sexual harassment mean in the context of the new duty? Well, it's the same language that we looked at earlier. So sexual harassment in this context means unwanted conduct of a sexual nature with the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. Importantly, the new duty to prevent does not extend to preventing either less favourable treatment of an individual because they either rejected or submitted to sexual harassment, or harassment related to any other protected characteristic, including harassment related to sex, i.e. where an individual suffers harassment related to the fact that they're a man or a woman, but the unwanted conduct in question is not of a sexual nature. The new duty extends to sexual harassment occurring in the course of employment. As before, that will cover sexual harassment occurring in the workplace, but it also covers harassment occurring at work-related events such as conferences, off-sites, parties, or leaving drinks, and even potentially online. So, what does the duty require? Well, the guidance tells us that the requirements of the duty on employers are twofold. Employers have to anticipate the situations when workers might be exposed to sexual harassment and take action in advance to prevent it from happening. Employers can't wait until an incident has occurred before taking action. And employers have to respond to situations where sexual harassment occurs by taking steps to prevent it from happening again. How many steps do employers need to take? Now, the eagle-eyed amongst you may have spotted that the new duty is less stringent than the all reasonable steps defence, in that it only requires employers to take reasonable steps rather than to take all reasonable steps. So you're not expected to do everything, just some things. Exactly how much is unclear. There is no one-size-fits-all, and compliance would be assessed by the Employment Tribunal on a case-by-case basis. Does the duty extend to sexual harassment by third parties? Well, I've already given you a spoiler there, and the answer is that yes, the new duty does extend to preventing sexual harassment by third parties. The EHRC guidance makes it clear that the duty to prevent requires employers to take steps to prevent sexual harassment committed by third parties, including contractors, clients, prospective clients, customers, service users, friends and family of colleagues, professional contacts, delegates at a conference, other people in a shared workspace, and members of the public. And there will sometimes be employer-specific third parties, for example, patients in a hospital, students in an academic institution. There will be some real challenges in practice for employers. The difficulty for employers is that compliance with this duty potentially puts you between a rock and a hard place. And I'm going to work through an example with you now. Now, we've learned the lesson here from baby reindeer. I just want to emphasize that any real life resemblances to the characters and events in this next example are entirely coincidental. In our example, Verity works for an advertising agency. She's assigned to work on one of the firm's most important client accounts. This involves her attending social events with employees of that client from time to time, usually involving alcohol. After one such night out, the star employee from the client company, Joel, makes a pass at Verity when they're traveling home together in a taxi. She manages to brush him off and get home. She reports the incident to her employer. Note that that report may be a protected act for victimization purposes. Mindful of its obligation to take steps to prevent it from happening again, the company, that's the employer, decides to move Verity off the client account immediately whilst it works out what to do. Eventually, it decides not to raise it with the client because they're concerned about upsetting one of their most important and valuable clients. Recognizing this would leave Verity and other employees potentially at risk of similar behavior from Joel in the future, the company decides it will only allocate male employees to work on that client account. Now here, the employer has taken steps to prevent Verity and other female employees from being sexually harassed in the future, but it's probably victimized Verity by removing her from the client account. It's probably committed an act of direct or indirect sex discrimination by excluding women from acting on a key client account. It could also be argued that the employer created a humiliating environment for her by moving her, and that this could give rise to a claim of harassment related to sex, i.e. being a woman. Verity could bring tribunal claims against the employer, and she may be minded to constructively dismiss herself and bring an unfair dismissal claim as well. The employer is potentially at risk of an aggravated damages award by not even raising the issue with the client, thereby protecting the perpetrator. So it's difficult. What could the employer have done differently in this situation? Well, the employer should have discharged its anticipatory duty by risk assessing scenarios where employees are attending work-related events, even those hosted by third parties. For example, they could have a policy of always sending people to such events in pairs and paying for transport home. They could have ensured staff felt empowered to leave events immediately if they felt unsafe. The employer should have already established a protocol in terms of how to respond to third-party harassment and covered this off in terms and conditions with the client. Here, the employer was caught on the back foot and they moved Verity whilst working out how to respond to what had happened. After it had happened, they could have talked to Verity about what she wanted to happen. She might have been willing to be taken off the account temporarily or even permanently, but by the employer imposing it on Verity, that could have amounted to victimization. If Verity wanted to stay on the account, it could have considered other ways to prevent repeat episodes. So, for example, asking her whether she would want to avoid the social events with the client altogether or attend but only with a colleague, giving her a budget to get her own taxi home. Of course, the employer should have reported the incident to the client, and its failure to do so was a major error by the company, as it leaves the alleged perpetrator in place, unsanctioned, and he could do the same again. If the report of the incident annoyed the client and they refused to do anything, this leaves the agency, the employer, in a tricky situation. There are just no easy answers here. The employer needs to balance its legal obligations, that's complying with the duty to prevent, whilst also not discriminating against its own staff, with its commercial interests, not losing one of its most valuable clients. So I'm going to hand over to Julia now, who's going to talk about the consequences of breaching the duty.
Thank you, Nick. Now that we have a better idea of what the duty is, I'm sure you're all wondering, well, what are the consequences of breaching this duty? And the key point to note here is that an employee cannot bring a claim before a tribunal about a breach of the duty itself. It's not a self-standing actionable claim for the employee. The duty and the related uplift to compensation will only be considered in the context of another harassment claim that is able to be brought against the employer. So the new duty to prevent affects the value of that claim rather than being a claim in and of itself. So how does that work? Where an employee succeeds in a claim of harassment against their employer under Section 40 of the Equality Act, which involved to any extent harassment of the kind described in Section 26(2), that being sexual harassment, and a tribunal has ordered compensation to be paid, the tribunal must then consider whether and to what extent the employer has breached their legal duty to prevent sexual harassment. And then where a tribunal concludes that the employer has breached that duty, it may then award an uplift to the compensation. and any uplift will correlate to the extent to which the employer has breached the duty, but won't exceed 25%. So again, what does that mean? Well, it certainly means that if you lose a sexual harassment claim, the tribunal will consider whether you have breached the duty and may then award the uplift to compensation of up to 25%. But what's perhaps less clear is whether this applies where the sexual harassment was conducted by a third party. So going back to Nick's example of Verity and Joel, let's say that Verity brought claims against her employer for victimization, direct sex discrimination, and harassment related to sex, and she wins those claims. Thinking about her harassment claim, for the uplift to be awarded, the tribunal will consider whether the harassment involved, to some extent, sexual harassment. And arguably, as an act of sexual harassment was the background act triggering the employer's harassment, there has been, in this case, an instance of harassment of the kind described in Section 26(2), that being sexual harassment. And therefore, sexual harassment by a third party could potentially meet the definition, and the tribunal would need to go on to consider whether the employer had breached the duty to prevent this and whether the uplift should then be awarded. All of which is a roundabout way of saying that, yes, we do think there's a route to an uplift in compensation, even where the sexual harassment has been conducted by a third party. And of course, where a tribunal rules that there has been a breach of this duty, you can also expect a much higher level of media interest and reporting. And in many cases, the potential reputational damage might actually be of more concern to you than the financial consequences of an uplift to compensation. In terms of other consequences, where an employer fails to comply with the duty, or if there's at least a suspicion that that's the case, the Commission will also be able to take enforcement action against them. And as an employee, whether they're a victim or not, can blow the whistle to the Commission about a suspected breach, this triggering enforcement action, this could actually occur outside of tribunal proceedings, and there's nothing you can do to stand in the way of that. The Commission themselves have a variety of powers here, so they can investigate an employer. They could issue an unlawful act notice, which confirms that the employer has breached the duty and requires it to prepare an action plan setting out how it's going to remedy that in the future. They can also enter into legally binding agreements with an employer to prevent future unlawful acts. These are known as Section 23 agreements. Or they could also ask the court for an injunction to restrain the unlawful act. So the Commission's enforcement action is also in the public domain, and you can see on their website details of current and past investigations held. For example, they've entered a number of Section 23 agreements in recent years with high-profile employers such as McDonald's to do with sexual harassment or their approach to harassment. And that's all publicly available information, so it significantly increases the reputational risks to an employer of failing to comply. That said, the reality is that the Commission has limited resources, so we do expect the focus of its efforts to be on the more serious cases. But in a recent press statement, the Commission did state that it will not hesitate to take action and that they are determined to crack down on workplace cultures of sexual harassment, whether that's in restaurants, hotels, sports clubs, or offices. So it's very important to consider. Again, now we know what the duty is, we know it has a broad scope and that it applies to third parties. And we also know that there are financial and potentially reputational consequences of breaching this duty. I'm sure we all want to know, how do we actually discharge it then? What do you need to do in the next 20 days or so to be prepared for this? The guidance stresses that compliance with the duty will vary from employer to employer, and there's certainly no one-size-fits-all approach to this. But what we do know is that all employers should take the following approach. So firstly, you need to consider the risks of sexual harassment arising in the course of employment within your business. In other words, you need to conduct a risk assessment. And it's worth noting that the guidance does state that an employer will be unlikely to comply with the preventative duty unless they have done that risk assessment. So this part is key. You then need to identify the possible steps you could take to reduce those risks and prevent sexual harassment from happening. And once you've done that, you need to assess which of those steps are actually going to be reasonable for you to take in light of a variety of factors, such as the size of your business and the resources available. And we'll come on to discuss that more. Importantly, and obviously, you then need to implement the steps that you've deemed to be reasonable. Now, as I said, there's a variety of factors relevant to whether a step is going to be reasonable for your business. And the guidance sets out the following factors which might be relevant to assessing whether or not a step is reasonable. Once again, not an exhaustive list, quite a lot of overlap, so do take them all into account. So firstly, the size and resources of the business. Unsurprisingly, more is going to be expected from larger, well-resourced employers, such as banks or larger law firms, and steps that might be reasonable to them might be disproportionate to a smaller business that's, for example, a startup. The nature of the working environment. This captures various aspects of your workplace, including the type of workplace. So are we talking about an office, a factory, a restaurant, and also the makeup of the workplace? Are you a particularly male-dominated environment where statistically the risks of harassment are higher? The sector you operate in is also relevant. Unfortunately, some sectors are known to pose a particularly high risk of sexual harassment, for example, the hospitality sector, and therefore it might be reasonable to expect more from employers in these industries. The specific risks present in your workplace. You will have identified at least some risks when doing your risk assessment, and you need to consider carefully what steps are going to be helpful to address those risks. The nature of any contact that your staff are going to have with third parties. What is the frequency of that? What environment will that be in? Is that going to be where alcohol is present? Will your staff be alone? These are all things to take into account. And if you recall in our Verity and Joel example, we had staff coming into contact on a regular basis with really important clients in social situations, and that's likely to increase the risk. The likely effect of taking a particular step and whether an alternative step could be more effective is also something to consider. That doesn't necessarily mean that it won't be reasonable to take a step just because you don't think it will be effective, but it's still something you need to think about whether it's reasonable or not. The time, cost, and potential disruption of taking a particular step, that might be implementing a new training program, that should be weighed against the benefits that it could achieve to see if it's disproportionate. Whether concerns about sexual harassment have previously been raised with you. If it's already happened and you've already taken steps and they clearly aren't working, then there's some that it's going to be, you're going to be required to take further steps, and it will be reasonable to do that. And then finally, compliance with regulatory standards. So as Nick's already mentioned, you need to consider whether the FCA or SRA regulations or any others that are relevant to your business should be taken into account here. So what kind of steps are you expected to take? Again, helpfully, the Commission has published an 8-step guide for employers on preventing sexual harassment. And this is said to illustrate the types of actions an employer can take. And again, whilst it's not exhaustive, it does state that implementing these steps will help you to take the positive action to prevent and deal with sexual harassment. Now, although it's been separated out into 8 steps, this was only done to assist employers, and we're going to talk through them in turn, but they do all overlap. And when you come to approaching them, it should be done concurrently, not separately. So they're not sort of in boxes. The first step is policies. Most employers will have a suite of policies in place, whether that's your standalone policies or a large staff handbook that's available for all. And ideally, you should have a separate policy for sexual harassment as compared to other forms of harassment. And certainly presentationally, at least, that shows an intention to address this topic seriously and as a standalone issue. The sexual harassment policy itself should cover what is expected and prohibited behaviour, how matters of sexual harassment should be raised, and maybe the different ways that you can do that, how they'll be dealt with once they are raised and any potential consequences. And the policy should also encourage staff to report instances of third-party harassment, and there should be a section that sets out how that will be dealt with by your business. Practically speaking, of course, we want the sexual harassment policy to align with any other relevant policies that you have. That might be disciplinary policies, a social media policy, or perhaps a relationship at work policy, which at the bare minimum, we would expect to set standards of behaviour at work, and also rules on disclosure of workplace relationships and what might happen if there's a perceived conflict of interest there. Again, you can't just put your policy in place, pop it on the intranet and forget about it. Employers should review these policies on at least an annual basis and make sure to check whether they need to be updated to reflect any new law, any trends within the industry that you might have found, or anything you might have picked up over the course of that year by consulting with your staff, which we'll come on to. It's worth noting that in the context of the reasonable steps defence, we have seen cases where employers' defence has failed because the relevant policy they've looked to as their defence hasn't been looked at or updated for a number of years. So although this doesn't sound that important, it is, and it's a really easy thing for you to do and get right. The next step is engagement with your staff. So again, you might roll out your policies on the first day. It might be something that you put up on your intranet, but that's not going to be enough anymore. With the new duty, you need to show that you've informed staff of your approach to sexual harassment, and you need to consider whether or not that means sharing the policy again or at regular intervals. Perhaps you need to send it round the night before the Christmas party, where the risk might be slightly higher. And depending on the type of business that you're in, you might also consider whether you need to communicate the policy in a different way. So does it need to go up on a notice board, or do you have an app that employees might be able to access it on? What's really key in this step is the engagement with your staff and this idea of consulting with them throughout the year about sexual harassment. You should be finding out their views on where the risks lie, and it might be that varies greatly across your business. More senior employees might have a different view of what the risks are to junior ones. And you could do that in different forms. So it might be that you do one-to-ones, or in your performance reviews, you bring it up, or perhaps you run an anonymous survey for your employees. We do really think this type of staff consultation will be particularly helpful if you end up in a situation where the tribunal is scrutinising your approach to the duty and whether you've complied. And you'll be able to say, we spoke with our staff, they told us what they were concerned about, and these are the steps we took to act on that. The next step is assessing the risk. So as we mentioned earlier, the guidance suggests that an employer will be unlikely to discharge the duty if they have not conducted a risk assessment, which looks at the specific risk of sexual harassment in your business. Before doing your risk assessment, there are different sources of information you might want to consult to help with your preparation. You might want to look at previous reports or tribunal claims to see if you can identify trends or red flags where sexual harassment is more prevalent. You should consider any workplace or industry-specific trends and any data that you might see. So as I've mentioned, is there a particular spike around the Christmas party or when there's a staff away day? And obviously consult with your staff as well, as we've mentioned. Now, the risks are going to vary from workplace to workplace, but there are some typical factors found across many different types of workplace which increase the risk of sexual harassment. So these are things like a power imbalance. The logic being that a weaker victim is less likely to be able to feel able to reject advances and or to speak up if something has happened. So you need to ensure that you've thought about how you're going to deal with complaints from different levels of employee, and spell out your approach to the workforce in your policy so that they have confidence that these concerns will be addressed. Something like lone working or night working is also sadly going to increase the risk. If there are circumstances where there are fewer or no witnesses, it's going to be easier for sexual harassment to take place and for the perpetrator to get away with it. So you might want to consider whether you need a policy of staff working in pairs, or potentially introducing things like code words that trigger safety protocols. The presence of alcohol, that's one we can't shy away from anymore. And in our experience is a big culprit for instances of sexual harassment. The query is it time to end the free bar? Do we need drinks tokens? Or should you go one step further and have designated sober chaperones, who are senior people who agree not to drink at an event and check on appropriate behaviour or ensure that your colleagues get home safely? These are all things to start discussing. Some other common factors that increase the risk are lack of diversity in the employment, insecurity for a particular group, or where staff are expected to attend a lot of external events. Once you've identified your risks, it's then a good idea to put these in order of priority by things like likely frequency or severity of the risk. And that will help you to tackle the most serious risks first, especially given that we now have a matter of weeks to undertake and implement some required steps. So you can put together an action plan of where you're going to go next. Step 4 is reporting. So staff should understand clearly how they can report sexual harassment and how that's going to be dealt with. And this should be set out in your policy and or covered in the training. You should give staff the option of reporting in a number of different ways. So in person, online, through an anonymous telephone service, perhaps. And you should certainly not place any time limits on when the reports need to be made. This is because workers who have been sexually harassed may not feel able to raise it within a particular period of time if they're particularly traumatized. When reports are made, you should ensure that they're dealt with appropriately. And of course, all of that information and evidence should be held safely and confidentially. And again, don't just leave your reports there on the system. You've done it, it's there. You want to be looking back at those over the year and trying to work out if there's any trends in those reports. Is there a particular team where this is particularly prevalent? And do you need to assess that? I'll now pass back to Nick for step 5.
Thanks. So step 5 is training. Training should be provided to all staff on the law so that they know what sexual harassment is, and also on your company's own procedures so that they understand how to make a report and what support is available to them. And your training should be tailored to your sector, and it should address any sector-specific risks or other specific risks that you've identified. It should also be tailored to suit different audiences. So in particular, those in leadership and human resources roles would need more in-depth training to help them role model good behaviours, spot sexual harassment, and know how to respond to reports of sexual harassment. Now, again, in the context of the reasonable steps defence, the Employment Appeals Tribunal in case law has highlighted that an employer will not have taken reasonable steps if the training it provides to staff just isn't good enough. High quality training has to be given, and you ought to keep records. Don't let anyone slip through the net. And if someone repeatedly fails to attend, then there should be a consequence for that. The training should be refreshed regularly. The question of how regularly depends in part on the employer. So for a large and well-resourced organisation, that might mean it should be rolled out annually. But for others, it might not be reasonable to do that given the cost and the disruption. So remember, even if a step isn't reasonable, there might be an alternative. So for example, a less well-resourced, smaller business might offer the in-person training every 2 or 3 years, but in the in-between years, send out links to written materials and webinars for staff to watch. When it comes to dealing with reports, you're expected to take appropriate and consistent action, and that will almost always include conducting a confidential investigation and taking steps to protect the victim from any further harassment or victimization. That might mean moving the alleged harasser to another team or another location, or if that's not feasible, suspending them. And throughout a process such as that, just you ought to keep in mind what support you can give to the victim. So for example, if access can be given to an employee assistance programme. Where a complaint is upheld, disciplinary action against the perpetrator will be needed, up to and including dismissal. Those who engage in unlawful conduct should not be protected or rewarded or promoted, even if they're very important commercially to the organisation. And that sends a clear message to staff that such behaviour is not tolerated. If you operate in a regulated sector and the perpetrator is a regulated person, or actually even if they're not and you're just the firm is, then you may have a duty to notify your regulator. And in appropriate cases, you should also speak to the victim about whether they wish to report the matter to the police. That is a matter for the victim. At the end of the process, it's a good idea to have a wash up and think about what you can learn from it. So does it reveal any problems with a particular part of the business or problems with certain activities of the business, or is there a cultural issue that needs to be addressed? How well did the process work? Could it be improved? And what steps, what additional steps could be taken to mitigate any identified issues? We've already mentioned that the risk of third-party harassment should be factored into your risk assessment and addressed in your policies and training, and staff need to feel empowered to report any third-party harassment to the employer. Third parties should be alerted to the employer's expectations around their treatment of your staff and the consequences of any harassment. And you could do that in a number of different ways. So there could be notices put up in the workplace. Potential contractors who are pitching for your work could be alerted of your stance on sexual harassment and your expectations. You could write to all existing clients and contractors to advise them of your stance on sexual harassment, maybe sharing your policies with them. You can ask managers to hold meetings with existing clients and contractors to discuss your approach and expectations. And you should ensure you have the ability to end a contract with a third party in appropriate circumstances. Critically, you should develop a protocol on how you would respond to reports of third-party harassment. Have the roadmap in mind now and work through what you would do in a worst-case scenario. Don't be caught on the back foot like in the scenario with Verity and Joel. And then step 8, keep in mind that it's an ongoing duty. So remember, you need to regularly evaluate the effectiveness of the steps that you've taken and consider what, if anything, you need to do differently. And there are different ways of doing that. So as I say, you could have a wash up after a complaint process is finished, consider historic complaints in the round to see if any trends are apparent, organise ongoing staff consultation like staff reviews, one-to-ones, sickness return to work meetings, exit interviews, foster a speak up culture and ensure staff feel supported to speak up and report harassment at any time. Consider putting in place specially trained workplace champions who staff can talk to in the first instance, have a mentor or buddy system. Keep your policies refreshed and updated, and evaluate whether any changes to the workforce need any consequential steps to be taken. So for example, if you acquired a business or a team, does that change the workforce dynamics, the demographics and your risk assessment? It's a good idea to designate responsibility for this ongoing evaluation to a team or particular managers within the business to make sure that it does happen. Just as an aside, it's worth noting that Australia has had a very similar duty to our new duty to prevent since 2022, and the Australian Human Rights Commission has issued very granular guidelines on the steps needed to discharge that duty. We're not going to go into that right now, but if you wanted sources of ideas and inspiration for steps you could take, then it would be worth a look. Back to Julia to talk about settlements.
Sorry, thank you, Nick. As a final very important point for you to consider, when it comes to settlement agreements and settling claims of sexual harassment, employers are not allowed to use settlement agreements to gag workers from blowing the whistle about various forms of malpractice, and that includes breaches of the Equality Act. So as we've mentioned, the Commission is a prescribed body for whistleblowing about breaches of equality law, which means that workers are entitled to make whistleblowing disclosures to them about such breaches. Therefore, even after a settlement agreement has been signed, a worker will remain entitled to blow the whistle about a breach or suspected breach of this new duty. And in turn, that could lead to enforcement action, which attracts negative publicity. And in addition to that, we all know that there are certain ethical rules in place that prevent solicitors acting on either side from signing off on a settlement agreement that purports to prevent an employee from making such disclosures. For example, a clause asking the employee to warrant that they're not aware of any reason that they would make that disclosure. So you do need to keep in mind that you're not able to stop that from happening. Thanks, Nick.
Okay, and now just to recap our top tips for getting started. So convene a working group with responsibility for your compliance, include within that a senior stakeholder. Ask the working group to read the EHRC guidance and receive training. And they could watch this webinar, for example, and then do your risk assessment and prioritize them in order of high to low. I think if you haven't done anything yet in preparation for the 26th of October, I think the risk assessment is the key thing. So you at least know where your risks lie and which are the important ones that need to be addressed. And you can start thinking about that. Consider which steps are reasonable to take, formulate your action plan and implement it by the 26th. Allocate responsibility for ongoing compliance and respond to complaints appropriately, taking further steps as necessary, and keep records of everything you do. Because if there was a tribunal claim or less likely enforcement action by the Commission, then those would be disclosable documents, and actually they may really help the employer in discharging improving its discharge duties. So that brings us to the end of today's webinar, which we do hope you found useful. On the slide, you see our contact details. Please feel free to get in touch with us in connection with anything that we've discussed today. And in the next day or so, we'll be sending out a copy of the recording and also the slide deck. If you'd like to stay on for the optional questions and answers, please do. And we'll be joined by Amanda. But if you're not able to stay, thank you very much for joining us today and feel free to sign out now.